Good afternoon. Happy Monday. Time flies when you're having fun. I have notes on my lap just so if you see me looking down, I am in fact looking at notes. Normally I don't have notes, but I took a few because I just watched a video this morning and I haven't really had time to go over and review it much, but I had jotted a few things down and I thought it was somewhat interesting. It is a Delete Lawz video. As you know, Delete Lawz is the latest, guru du jour. It's really weird to me, the overlap in the sovereign citizen community in this community, where people will accept a guy who was a Power Ranger as some sort of a constitutional expert simply based on him saying that I've been studying the Constitution for the last 20 years. Simply based on that, now they accept him as an expert. That just baffles me. It just baffles me. And to listen to the guy talk, I'm not a constitutional expert. I am a licensed attorney, licensed to practice law in the state of California. I have been admitted to the Eastern District of California federal bar. So I've practiced in federal court and I've practiced in state court, and I've dealt with constitutional issues. But I'm not a constitutional expert by any stretch of the imagination. But I can catch the errors that Chili makes. They're blatant. They're just like in your face, kind of blatant. Like, how is anybody buying this? And then I realize it's the old grifter technique. You tell the people what they want to hear. You say, I'm an expert, and you're right because I'm an expert and I'm agreeing with you. And people are like, oh, this is great. It was great, and they slurp it up. So anyway, in this latest video, it was Kristi Roan, obstruction of justice. That's what Chili titled his stream. If I'm not incompetent, I will put a link to it in the comment section below or in the description, somewhere down in there. At the roughly 22 minute and 55 second mark, Chili is talking to someone who I'm going to assume is Kristi Roan. And he had been complaining about her defense attorney forcing her to take a plea. Now, I don't know how that would even happen. You have to go in front of the judge, and the judge is going to ask you questions about it. Like, are you doing this are you doing this freely and knowingly? And, are you guilty? I guess with an Alford plea. I'm not sure what district they're in. If they're in Ohio, I don't know if Ohio accepts Alford pleas. They're not accepted everywhere. But I'm assuming either she has to plead guilty and say, yes, I am actually guilty, and I know I am guilty, or she has to do an Alford plea, which is basically like saying, I'm going to plead guilty because the evidence will prove beyond a reasonable doubt to the judge and jury that I'm guilty, but I'm innocent. The evidence will convict me, but I'm innocent, and that's why I'm pleading guilty. So that's an Alford plea. And I know it's not. I know they don't accept them everywhere, but I think most federal courts accept them, if not all. Anyway, so she's going to get a chance, if she does accept the plea, to go in front of a judge and tell the judge. And if she says, no, I don't accept the plea, well, then she doesn't accept the plea. It's always up to the defendant. The attorney can't accept the plea for the defendant. Cannot. Absolutely cannot. Period. I don't care what jurisdiction you're in. The attorney cannot accept the plea for the defendant. The defendant has to accept it and get in front of the judge and say, I, the defendant, am pleading guilty. And either I am guilty or I would be proven guilty. So either way, there you go. So like I said, at the 22 minute and 55 second mark, we know that the gal's represented by an attorney. And Chili's in there muckraking and talking about malicious prosecution because he learned about Thompson v. Clark, which is a Supreme Court case that just dealt with malicious prosecution and what you have to prove, a distinction that was drawn by one circuit that you had to actually have some sort of an affirmative showing that you were innocent. The Supreme Court said, no, you just have to basically have the prosecution finish without you being found guilty, without you being convicted of anything. So like it has to be dismissed or dropped or something along those lines. You can't get convicted and you can't plea out, basically is what they're saying. But there's nothing in there that says you have to have some sort of affirmative showing that say that you're innocent. Just either you get found not guilty or they drop the charges or whatever. So that's his latest thing. And so now everything apparently for Chili is about Thompson v. Clark. And so anyway, he's raking the muck, as he is a muckraker. And the prosecutor walks by and he says, hey, are you the prosecutor? And the prosecutor's like, yes, I am. And he says, we'd like to talk to you. And I think the prosecutor said something along the lines of like, who's we? And Chili says something along the lines of me and the person that you're charging. Now, in every district that I'm aware of, and according to the model rules of ethics for attorneys, you cannot, as an attorney, talk to a represented party. You have to go through the attorney. If you know that that party is represented in the matter you're dealing with them in, you have to go through their attorney. You have to. There's no end runs where you could talk to the client around the attorney. The whole point of it is so that the client gets the information from her attorney. And so when she gets the information, her attorney can explain it and explain the consequences and explain, the likelihoods of success, etc. It's to prevent the opposing counsel from basically badgering your client into doing something that your client would not otherwise do if they were getting good, solid advice from you, right? So literally the prosecutor cannot talk to this person. So obviously he just keeps walking, and Chili follows him and decides that he desperately wants to start a conversation with this guy. And he says something along the lines of, we just gave her attorney a thumb drive where the cop said that she didn't do anything. I think the cop said she didn't do anything. Something along those lines, something to that effect. I obviously haven't watched it in a while, so I'm loosely paraphrasing it, but again, 22 minutes and 55 seconds. You could watch it. It'll take you about 30 or 40 seconds to get through the entire thing, I think. So apparently the attorney Chili gave her attorney a thumb drive with video of the cop saying to her, you didn't do anything. Now, cops can lie to you. Cops can and do lie to you, especially when they want to get you to talk. And so it's absolutely meaningless. The cop he's not perjuring himself, and the cop can lie to you. And you get the cop on the stand and say, did she do anything? And the cop says, yeah, she did. Well, but you said that she didn't do it. Yeah, I was trying to get her to talk to me. I was trying to get her to admit it, blah, blah, blah. It's a nothing burger. It's zero. If you have ever had any criminal case ever, cops lie. Cops lie. And cops file inaccurate reports. And cops talk out of their ass. This is not rocket science. This is not rocket science. And it boggles me that people in this community know that cops lie, and they'll tell you that cops lie, but then a cop says something that they want to hear, and all of a sudden it's like, oh my God, this is the gospel truth. A cop said I didn't do it, so I couldn't have done it, right? No, it doesn't work that way. They're liars. It's like David Earl Warden. He's a liar. Earl David Warden. He's a liar. It doesn't matter if he says something you want to hear or don't want to hear. He's a liar. Don't trust him. Don't trust cops. They lie. Anyway, I'm getting off on a tangent. So it's a nothing burger, right? And so then Chili says, you have to dismiss this case or I'll file a malicious prosecution case under Thompson v. Clark 2022. And the attorney, the prosecutor is like, okay, thanks, bye. Because the attorney, unlike DeCastro, is an attorney. And he knows that what DeCastro just said was freaking retarded. If DeCastro, if you want to sue me for defamation, now is your opportunity, because you're a retard, sir. You, sir, are a retard. You are an imbecile when it comes to the law. Where do I begin? Where do I begin? Do I begin with the obvious? The obvious thing is, apparently she's about to plea. That's not a finding of not guilty. That's not having it dropped. That's not guilty. That's her pleading out. You have to wait. Even under Thompson versus Clark, the court said you have to have the prosecution end in a way that's favorable to you before you could sue for malicious prosecution. If she pleads out, it has not ended favorably for her. If she hasn't pled out, it's not done yet. It hasn't ended. Either way, you're not filing crap. And if you do, dismissed. 12B6, failure stated claim. Bye-bye. Second most obvious reason, standing. Chili can't file for malicious prosecution on her behalf. She would have to file. She would have to sue the prosecutor for malicious prosecution because she's the one who has been harmed. I mean, obviously, I don't believe that it's a malicious prosecution because I don't know the facts. I don't have any belief either way. But if she was going to sue, it would have to be her suing because she would be the one who's harmed because she's the one who's going to be wrongfully run through the system, spending all the time and hiring attorneys and money and all lost work, etc. She's the one who's harmed. Chili's not harmed. He can't file. He does not have standing to sue for her. He's not her guardian. He's not her conservator. He's not her dad. I mean, she's not a minor. He can't sue for her. So you lose there, son. And then the third thing is prosecutorial immunity. I know you guys don't like immunity. I know you don't. But a handy little United States Supreme Court case, Imbler versus Pactman, and unlike Chili, I'll actually give you the citation. It's 424 U.S. 409, Imbler versus Pactman, P-A-C-H-T-M-A-N, established that you can't sue under 1983 a prosecutor for bringing charges or presenting the state's case. You can't do it. Apparently, they're going to do malicious prosecution because this guy brought charges. He hasn't even presented the state's case yet. You lose. Flat out immunity. Prosecutorial immunity. Absolute prosecutorial immunity. If they're bringing charges or presenting the state's case, prosecutorial immunity. Now, maybe there is some state law that allows him to sue for wrongful prosecution, but I'm going to say that I'll bet anybody a shiny nickel, that there is immunity for prosecutors in that, for actual, district attorneys and assistant district attorneys or whatever they call them in Ohio. I'm going to bet you that there's in the state law for malicious prosecution that it doesn't apply to prosecutors doing their job, filing charges for the state. So just what he said was stupid on so many levels. On so many levels. And you know what? He keeps bringing up Thompson versus Clark, but he has not read it or doesn't understand it or something, because he should know that it has to end. The prosecution has to end with a not guilty or being dropped. It has to end. He should know that. Ongoing case has not ended. Basic stuff. I mean, you don't have to be an attorney to figure that out. You just have to read the case with, I don't know, maybe a 7th level or 7th grade level of reading comprehension ish to be able to comprehend what the sentence means. Anyway, thank you for watching. Have a great day.